going in depth about the impacts of this decision. Joining us to talk about it is California Western School of Law professor William Aceves.
Thank you for joining us. Now, for states with trigger laws, those states have already banned abortion. Is there really anything abortion rights proponents can do at this point?
In those states, there are a number of states that have either never reversed their original restrictions on abortion despite the Supreme Court's earlier decisions, or, as you noted, have subsequently adopted trigger laws that would go into effect once the Supreme Court overturned Roe v. Wade. And so in those jurisdictions, I would anticipate that advocates of reproductive freedom would be filing lawsuits to challenge implementation of those laws. Now, while it's true that the Constitution no longer provides a right to abortion, that doesn't mean that there may not be local or state arguments that could be made against implementing those laws in those individual jurisdictions.
And Professor, a lot is being said about Justice Thomas's concurring opinion, where he said justices should reconsider precedents on contraception access, same-sex relationships, same-sex marriage. Is there a danger of those rights being taken away?
It's an interesting question. On the one hand, the majority opinion issued by Justice Alito indicates that this case was focused exclusively on the right to abortion. But as you pointed out, in Justice Thomas' concurring opinion, he calls out all of these other rights that really were premised on the same underlying idea and value that Roe v. Wade was premised on, which is a right to privacy, a right to individual autonomy and decision-making. And so it is absolutely true that these future rights, or these fundamental rights that you alluded to, could be subject to restriction in light of how the court analyzed and critiqued and limited abortion in this decision.
And Professor, do you think we will see an increase in abortions here in California? Will there be an economic impact?
Well, as you alluded to in your remarks a few moments ago, one of the practical consequences of the Supreme Court's decision is that women will have limited access to abortion procedures in their own states. And so we will expect to see an increase in women entering California for purposes of accessing health care support. And so there will be an increase in abortion procedures in California because women in states that have limited that right will need that type of support and that type of health care, and they will look to other states that do allow it. And so we will see an increase in the number of women entering California for purposes of accessing medical health care.
And the professor, really quick, I want to go back to Justice Thomas because a lot is being said online, where he mentioned the precedents on same-sex marriage, contraception. He did not mention Loving versus Virginia, and a lot has been said online about that. What are your thoughts?
It's an interesting question. I can't speak to what Justice Thomas was thinking. But if we accept his arguments that other fundamental rights not explicitly stated in the text of the Constitution are not subject to constitutional protection, that argument would extend to Loving v. Virginia, which was an incredibly important Supreme Court decision issued in the 1960s, which held that state efforts to restrict interracial marriage were unconstitutional. If we accept Justice Thomas's position that other fundamental rights are not entitled to heightened constitutional protection, that argument would also apply to Loving v. Virginia, which means that in principle, in theory, states could impose restrictions on interracial marriage, which is candidly ridiculous.
All right, Professor, thank you for all that information you provided us this morning. We appreciate it.
Of course, thanks so much.